Hello everybody, and a very warm welcome to this National Conveyancing Week session, where we're going to be looking at some of the key compliance issues that conveyancers need to keep their eyes on. My name is Brian Rogers. I'm Regulatory Director at Legal Access, part of the Access Group. And today, I just want you to remember that my aim is not to frighten you. It's really to tell you what's going to be coming around the corner so that you can actually head off the issues that are coming. So, don't shoot the messenger, please. So what are we looking to do here? Well, we're looking to give you a little bit of an insight into the sorts of issues that are around the corner or in front of us at the moment, as some of them are. And really what we want to try and do, as I said at the very beginning, is to try and give you insight so that you can actually stay out of trouble and obviously keep away from the various regulators. So starting off with money laundering, well, we all know, or we should all know, that the conveyancing side of things is very much high risk as far as money laundering is concerned. So of course you need to make sure that you're doing all you can to keep in compliance with the money laundering regulations. And that includes maintaining your firm-wide risk assessment. That will be one of the first things that the regulator of whatever type they are, whether it be the SRA, the Solicitors Regulation Authority, or whether it's the Council for Licensed Conveyancers, but they would all normally ask you for your firm-wide risk assessment, because that's pretty much what is at the top, and then everything else flows from that, including the risk assessments to do with the client and also the matter. So you need to be making sure that you do one of those for each transaction and each particular client, so that you've got everything that you need to have there, including client due diligence and all the other things that make up part of that particular assessment. We've seen a lot of activity by the various regulators in relation to checking compliance of the money laundering regulations and the rules and regulations around all of that. And we saw very recently, certainly with the Solicitors Regulation Authority, the highest fine given in this particular area so far, of around about £20,000, I think it was. But what we've also got coming around the corner, don't have a deadline for it or a timescale for it yet, but basically there are going to be unlimited fines coming out with the SRA for money laundering breaches, and they're looking to actually extend those to any form of sort of financial crime. So we need to be making sure that we don't get caught up in relation to all of that. Another thing that we've got coming around the corner, well, I say coming around the corner, it is coming around the corner, but there's looking at it already, and that is transparency. So conveyancing, it's one of those areas that very much falls into this particular area of the rules. So we need to be making sure that we're looking at our websites if we've got one, and I'm going to work on the premise that we all do have a website, and therefore we need to be making sure all the relevant information that we have to put on there from a transparency regulations perspective is concerned, are there. So we have again seen a fine very recently given, again highest for this particular type of breach. It was about £3,500. So we need to be making sure that we don't open ourselves up for criticism by the regulators and then end up getting fines, because at the end of the day, if we're in conveyancing and we're part of the CQS scheme, then we could end up having that scheme membership suspended or taken away from us. And of course, we know what would happen if that happened. The lenders wouldn't be very happy, and we'd probably lose our panel positions. So need to be really careful there and make sure that we're doing all the right things from a transparency perspective. One of the other things that's coming around the corner, we've got the 1st of April, and this is not an April Fool's joke, I have to say, and that is the Legal Ombudsman's scheme rules. They're being changed from that date. The key change is to the deadlines for referring a complaint to the Legal Ombudsman, and these will reduce to 1 year from the previous 6 to 3 year deadlines that we are used to operating with. And the LEO will still require complainants. There's no change here. They will require the complainants to refer the complaint within 6 months of the date of the final complaint response. So that's the response from you, in effect saying to the complainant, sorry, we think we've resolved this matter. If you're not happy, then you need to go to the legal ombudsman. So what do you now need to do? Well, you need to update your clients on the changes. That is before the 1st of April. So you need to be moving on things as quickly as you can to make sure that the 1st of April deadline is obviously met. And you can do that in several ways. Leave it to you to determine what is best for you. And there isn't any guidance, unfortunately, from the regulators or the LEO in terms of how they would like you to notify your clients. So just a couple of suggestions. You might want to put an email footer on your emails to highlight the fact that there's going to be changes. You might want to update client care letters, terms and conditions. Your website, for example, that will need to be sorted out as well. So leave that up to you. But of course, you need to be making sure that those who are under the existing rules are told that they're going to change on the 1st of April. And of course, going forward from the 1st of April, you need to be making sure that your complaints procedures and the information you give to clients are updated to reflect the new rules. One of the other things that the SRA certainly, well, I say the SRA is obviously the main regulator in the legal sector, but the other regulators are looking at this as well, including the Legal Services Board, the oversight regulator, and they're looking at competence. And it's from social media, and one of the places that you might want to have a look at, particularly relating to conveyancing, is when conveyancing goes rogue, and that's a Facebook page. And we've also seen some national press issues, particularly in the Sunday Times, where they basically highlighted one particular firm. And as media does, it tends to take things out of context, and it looks as if that's what they did in this particular case. But the story behind it was basically that this firm was getting a lot of complaints from people who were unhappy about the way the firm was dealing with their conveyancing matters. But quite clearly, you know, when you look at when conveyancing goes rogue, you can see that there are all sorts of issues out there. And I have to say, I have a look at and I advise on compliance to the Bold Legal Forum. And quite clearly, there are issues there even being encountered by other legal professionals. So searches that are not appropriate and things like, and inquiries that are not appropriate. So, you know, we need to be making sure that we ourselves are doing the right things so that our clients don't actually complain. But competence is another area that's subject to a thematic review by the SRA, and I'm sure the CLC and others will be looking at it as well. And of course, the track record of the SRA when it does thematic reviews is to actually send out an email to you to say, please, can you confirm that you are compliant with whatever the topic area is, and in this case, it's competence. And if you say, yes, we are doing all the right things from a competence perspective, then don't be surprised if it then comes back and actually wants evidence to show that you are compliant. You can't just turn around and say, yes, we're compliant. And that's happened in a number of previous thematic reviews, particularly around AML, where people said they had actually got a compliant firm-wide risk assessment when in fact they hadn't, and they were punished as a consequence of that. So, you know, don't put yourselves in a situation where you could be found guilty of misleading your regulator. So, no just ticking boxes. One of the issues that we've had on our radar for quite some time, and I'm sure you have as well, as far as the source of funds is concerned, has been property funds coming from China. And I've certainly been pushing the SRA in relation to getting an answer to this in terms of when are we going to get guidance and things like that. As far as the SRA is concerned at the moment, is they've got comments from the National Crime Agency, who has to have some input into all of this, and they're now in the process of incorporating that into the guidance. And once they've done that, it will then go to the legal sector affinity group, and it will then need to have the group's sign off and approval. As I understand it from the SRA, that is going to be a while off yet, so we don't have any confirmation of that. But I think the best advice for everybody is if you do have someone coming in and wanting to do a transaction that involves funds from China, is put in a defense against money laundering. And then, hopefully you will get that defense and you can then go forward. They do seem to be, and this is not a guarantee, but they do seem to be given as a matter of course at the moment. But if you put it in, just see what happens. You can't be criticised for that then. You have reported, and hopefully you'll then get the defence and you can then go forward as you would normally do. But don't go ahead without doing all the relevant checks and then getting the authorities. So, I appreciate that you're all very, very busy people. What you mustn't forget is the fact that you have third parties that you've got to appease and keep happy. And that obviously includes the regulators. But apart from the regulators, you've got to make sure that your professional indemnity insurers are happy with you. And, generally, they are not happy insuring property and conveyancing. They're already on heightened alert. And as I said right at the very beginning, property is high risk. And so, they are very, very cautious about things. And if they have any excuse to sort of say, right, well, we're not going to cover that firm, then the likelihood is they will use that and say, well, we're either not going to cover you or we're going to put your premiums up substantially. We've also got CQS for those firms that are members there. And of course, if you lose CQS, as I said earlier on, you really do have a problem, particularly if you are reliant to a large extent on property work. Because if the lenders start to get worried and they start saying, well, we're not going to have you on our panels and things like that, then in effect you've lost them, and you've lost those positions, and the likelihood is you're going to lose your business. So it is critical that you meet all the requirements of CQS. But don't panic. You're not on your own. You do have people to help you, like us. We are here to help you. We have got lots of services and products that we can help you with, including a policy and precedent library. So we can, we put all the policies together. But of course, as the SRA has said on numerous occasions, you can't just have a template and then just put it in place without making sure that it's fit for purpose for your particular firm and your particular circumstances. And we would hate to have our policies going out there and people just basically incorporating them, but not taking out the boxes that say insert the person's name here. And that has happened. The SRA has had that sort of thing. We also have CQS training. In addition to other types of training, we are the only other provider of CQS training outside the Law Society. So, we are here to help you in relation to that. And we also have software systems like our risk and compliance system that helps you to maintain the evidence that you need to show to regulators that you're doing all the right things. It's also to help you manage what you're doing in terms of compliance. I also have a lot of people, I think we have over 1,600 people now a month registered for our free, and I emphasize the word free, and who wouldn't want to come to things that are free. We have a free monthly compliance update where we talk about what's going on in the legal sector around the regulators and operational issues and things like that. And we've had some really good feedback from the attendees to say they wouldn't miss it. It's part of their routine, and they find them really, really useful. As do a lot of people who have connected with me on LinkedIn. So if you're on social media or if you're on LinkedIn, come and connect with me, because if I pick up topics on the regulation and compliance side, I will be commenting on them on LinkedIn on a fairly regular basis. So actually, if you want things sooner than perhaps the monthly update, then come on LinkedIn and we can get that to you. So to put it simply, we are here to be your fence. So that is to stop you falling over the cliff. So we're the fence at the top of the cliff, and we're here to stop you falling over the cliff, rather than being the ambulance sitting at the bottom waiting for you to fall. So, use us. We want to be your trusted advisor in terms of risk and compliance and conveyancing. So, use us. we are here. So thanks very much for taking the time out of your busy schedules to watch this and listen to me. I hope you've found it useful. Of course, if you do want to contact us to talk about anything, then by all means, please do, and we'd be delighted to help. Thanks very much. Bye-bye.